Start. It is the case of the petitioner that prior to 16th June 2006, the respondent number 1 was the owner of the REIT property. On 16th June 2006, the original respondent numbers 4, 5 to 7 being consenting party executed a registered agreement to sell in respect of the REIT property in favor of the petitioner, thereby conferring all rights, title, and interest in respect of the REIT property in favor of the petitioner. On 24 December 2012, the original respondent number 4, through his power of attorney holder, made an application dated 12 April 2012 to the learned additional collector of Raigad at Alibag for sale of the said property. It is the case of the petitioner that the learned additional collector, after considering the said application opinions of the learned Tahsildar of Panvel and Sidco, passed an order thereby granting permission for sale of the said property under section 43 of the Maharashtra Tenancy and Agricultural Lands Act 1948 and rules made thereunder. Para. On 13th February 2013, the respondent number 4, through his power of attorney holder, executed a registered sale deed in favor of the petitioner, thereby conferring all rights, titles, interest in respect of the said property in favor of the petitioner. On 7th December 2013, the respondent number 1 issued a notification which was published in Maharashtra Government Gazette on 16 December 2013 under Section 4 of the Land Acquisition Act 1894 regarding intention to acquire the lands at village Taluka Panvel, District Raigad for Navi Mumbai project and included the REIT property in the said notification. Para. On 1st July 2014, the petitioner made an application to the respondent number 3 and informed the Special Land Acquisition Officer that the petitioner had purchased the REIT property and therefore and that the respondents should make all correspondence in respect of the acquisition of the said property with the petitioner only. On 4 August 2014, the petitioner made an application to the respondent number 3 and informed the Special Land Acquisition Officer that the petitioner had purchased the REIT property and therefore should make all correspondence in respect of the acquisition of the REIT property with the petitioner only. On 5 August 2014, the respondent number 3 addressed a letter to the petitioner assuring about conducting an inquiry about the grievances of the petitioner and that the decision of the said inquiry will be communicated to the petitioner. On 20 May 2015, the respondent number 1 decided to acquire the REIT property and issued a declaration under Section 6 of the Land Acquisition Act 1894, which came to be published on 20 May 2015 in Maharashtra Government Gazette regarding acquisition of the REIT property for Navi Mumbai project. On 23 June 2015, the petitioner made an application to the respondent number 2 and raised his objection for making any correspondence with the earlier owners of the REIT property. On 28 August 2015, the respondent number 2 passed an order property under section 9 (3) and 4 of the Land Acquisition Act 1894 directing to declare an award in the name of the earlier owners of the writ property. It is the case of the petitioner that the respondent number 2 totally overlooked the sale deed executed by the earlier owner in favor of the petitioner. A copy of the said order dated 28 August 2015 was sent to the petitioner in the last week of December 2015. The petitioner thus filed this petition on 31st October 2016 for various reliefs. Para Mr. Y.S. Jahagirdar, Learned Senior Counsel for the petitioner, tendered symphosis and also brief written argument and copy of the plaint in suit number 4229 of 2022 filed by the respondent numbers 9 and 10 against respondent number 7 Sanjay Madhukar and others including the petitioner herein. He also invited our attention to the various documents annexed to the affidavit in reply filed by various parties. He submitted that prior to the notification dated 7 December 2013 issued under Section 4 of the Land Acquisition Act 1894, the acquisitions proceeding had already commenced in year 1970, since no award was rendered by the Special Land Acquisition Officer in pursuance of the said notification issued in the year 1970 within the time prescribed under Section 11A, that is, within 2 years from the date of declaration of notification under Section 6 of the Land Acquisition Act 1894, the acquisition proceeding initiated earlier lapsed. It is submitted by the Learned Senior Counsel that Section 4 notification was once again issued on 7 December 2013 in respect of the writ property, followed by notification under Section 6 on 20 May 2015, that is, after expiry of 1 year from Section 4 notification, which itself is a patent illegality